Good day, fellow subscribers, friends of the channel, South Africans in general. Allow me to indicate to you that we are now on Series 7. Series 7, yes, it's been that long. We've been busy, we've been grinding, and we've been learning in the process. And we are now at Series 7. And in Series 7, I will be touching a little bit on the test for recusal. Remember, we went through in series 5. We looked at the essence of what the reasons for advancing or for recusal by Mr. Jacob Zuma were, as advanced by his legal team. And then in series 6, we then looked at the reasons against the recusal as advanced by Advocate Pretorius of the Commission of Inquiry. Now, in series 7, then we look at the test. And then in the last series, we will then look into whether or not the reasons as advanced by Mr. Jacob Zuma and his legal team then meets the test for recusal, such that then we will see maybe the Deputy Chief Justice recusing himself. Now, before we get into the test, I must indicate that whenever one talks about the recusal, there is a certain obligation that any presiding officer, judge, magistrate has, generally, even chairpersons of commissions have, is to sit in any court or to sit in any commission wherein they are not required to recuse themselves. So that is the core of it all. And in order for you then to argue for the recusal of the presiding officer, judge, chairperson of a commission, it is a mountain and a half. It is a mountain and a half. It's not going to be handed to you on a silver platter. So allow me then to indicate, to start with then the grounds for recusal. One of the grounds of recusal relates to the fact that there must be real or reasonably perceived conflict of interest. So whenever a conflict of interest rears its ugly head, that would be a very clear ground for recusal. The other relates to the reasonable suspicion of bias, a reasonable suspicion of bias, and this would then of course be based upon objective facts. And remember, the chairperson will not recuse him or herself if really there are no sufficient grounds or there are insubstantial grounds for him to recuse himself. So you really have to come up with an A game. You really have to be convincing, and then you would get your recusal. But now that you understand what the grounds are, then it's important for us to move to the second phase, where we look into the actual test. What is the test for recusal? Now, recusal is one. Actual bias is not really one of the requirements for recusal. But as has already, I'm sure you've already heard when you also yourself were listening to the parties, is that the test is a requirement of a reasonable apprehension of bias. The test is a reasonable apprehension of bias. Now, what does this all mean? Now, remember now, Mr. Jacob Zuma comes and says to the chairperson, I've got certain fears, I've got certain apprehension in terms of how you will handle my matter. Now, we need to test essentially this fear, this apprehension that Mr. Jacob Zuma has, and we test this against two important requirements. One, we'll look at the reasonableness of the facts that he would be presenting. So if the facts that Mr. Zuma and his legal team are presenting are reasonable, strictly speaking, they would get to succeed. But another requirement there of objective requirement is that there must be a reasonable person. In other words, when we make an assessment, or when we test this fear or apprehension, we are not looking at the individual called Jacob Zuma. We are looking at a reasonable person. For example, in this case, we are dealing with a former president. So in applying that test, we look at the person of, for example, the post that he had, the power that he had, the knowledge that he had, the information that he had at his disposal. So we will compare apples with apples. So Mr. Zuma clearly will be considered on a much, much higher standard than an ordinary person. And obviously then the said assessment, when you test this apprehension, must definitely be a reasonable assessment. It must be a reasonable assessment. Only then can you meet the requirement for recusal. So it's not something that you get on a silver platter. And we will look shortly at a number of cases and how they are applied. Now, allow us then to get into explaining what this reasonable apprehension means. One, we indicated that obviously this was argued, I think, very well by our advocate Kakane, to say that whenever we are sitting, there must be a form of impartiality and independence on the part of the presiding officer, or in this case, the chairperson. In other words, when the chairperson deals with the issues before him, he must definitely act fairly and in discharging his investigative executive function, especially as it relates to the commission of inquiry. Secondly, he must be fair. It doesn't matter, and this they advanced, that the proceedings are formal or informal. He definitely has to be fair. And then one of the other things that they indicated is that it doesn't matter whether the judge is acting in a quasi-judicial function, but he cannot be stripped of this requirement of impartiality. I think for me, I cannot really try to argue that the chairperson ought not to be impartial. I think it is an important issue. But this is where now the actual application of this principle comes in, and the context in which it would find application. Because for example, remember, we are still dealing with a commission of inquiry. Now, in a commission of inquiry, as I've explained in earlier series, we are not dealing with a court process per se. We are dealing with basically a inquisitorial procedure, and we are not dealing with what we call adversarial procedure. So in an adversarial procedure, it follows more or less the system in a court, where a judge basically is not in the arena, he is outside. The counsels, the representative for the people representing the parties are the ones in the arena. They are the ones asking the questions. They are the ones engaging, and the judge is just basically sitting outside and looking and trying to listen attentively, so that he can then be in a position to make a decision, or in this instance. But in an inquisitorial process, the judge is in the arena, the judge is asking questions, the judge is putting versions, the judge is trying to understand the impressions that people are making, so that he can then make a finding. And a typical example of that, and really don't laugh at me, is, for example, your Judge Judy. Your Judge Judy, there comes parties before her, and then she is the one engaging the parties and asking virgins, questioning, so that she can then come up with a decision at the end of the day. Now, let us look at what South African courts are saying as far as it relates to this test. And the first case that we are dealing with, and I will really read some of the paragraphs verbatim so that you can understand the gist of how the judges go about dealing with this. And the first case is the President of the Republic of South Africa versus the South African Rugby Football Union and others. It's a 1994 case, and it's a 1999 case, and it's a constitutional court case. Now, in paragraph 48, the court says then, and I quote, "It follows from the foregoing that the correct approach to this application for recusal of members of the court is an objective one. The honors of establishing it rest upon the applicant, and the question is whether a reasonable, objective, informed person on the correct facts can reasonably apprehend that the judge has not or will not bring an impartial mind to bear on the application of the case. That is a mind open to persuasion by the evidence and submissions of counsel. The reasonableness of the apprehension must be assessed in light of the oath of office taken by the judges to administer justice without fear, favor, or prejudice, and their ability to carry out that oath by reason of their training and experience. It must be assumed that they can disabuse their minds of any irrelevant personal beliefs or predispositions. They must take into account the fact that they have a duty to sit in any case in which they are not obliged to recuse themselves. At the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial, and a judicial officer should not hesitate to recuse him or herself if there is reasonable grounds on the part of the litigant apprehending that the judicial officer, for whatever reason, is not and will not be impartial. So that is what they are saying in the Saru case, and I think this provides us a clear indication of what the tests are, where the honors lie, and actually an explanation of the type of person that we would ordinarily deal with in this case, the reasonable person test, and the fact that we must deal with objective facts, not just a subjective, one-sided understanding of the issues. Now, that is the first thing. If you would recall, secondly, the case is the Sakau case, and it is essentially the South African Commercial Catering and Allied Workers Union case. And then in that case, they basically go back and quote the Saru case. But I want to go to the last part of that case where they say, and it's in paragraph of 12, I think the last part, starting with, at the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial, and a judicial officer should not hesitate to recuse him or herself if there is reasonable grounds on the part of the litigant for apprehending that the judicial officer, for whatever reason, will not or was not and will not be impartial. And then I want to then move to another case, and then we will start to engage shortly. Is the State versus Dube case. It's a 2009 case, and it's a Supreme Court of Appeal case. If you move then to paragraph 13, it says there, the rule is clear. Generally speaking, a judicial officer must not sit in a case where he or she is aware of the existence of a factor which might reasonably give rise to apprehension of bias. The rationale for the rule is not that one cannot be a judge in his own case. The rationale for the rule is that one cannot be a judge in one's own case. Any doubt must be resolved in favor of recusal. It is imperative that judicial officers be sensitive at all times. They must, of their own accord, consider if there is anything that could influence them in executing their duties and that could be perceived as bias on their part, and it is not possible to define or list the factors in total that may give rise to an apprehension of bias. The question is, what is proper will depend on the circumstances of each case. And then there is another case, and I think South Africans, this is the last one. It deals with State versus SSH 2017 case. It's a Supreme Court case. There we look at paragraph 21 and 22, and it says, in order to justify a recusal, either at the instance of a litigant or the judge recusing him or herself, Merimutu, it must be demonstrated that the apprehension is that a reasonable person based on reasonable grounds. So the reasonable person based on reasonable grounds. The presumption of a judge's impartiality is not easily, the presumption of the judge's impartiality is not easily dislodged and requires cogent, convincing evidence or reason to rebut the presumption of judicial impartiality. A judge has a duty to hear a case unless the test for recusal is met. I have to South Africa repeat paragraph 22 because it is crucial to what we are dealing with here. It says that a presumption of a judge's impartiality is not easily dislodged. It requires cogent, convincing evidence or reason to rebut the presumption of judicial impartiality. A judge has a duty to hear a case unless the test for recusal is met. You know, there's something that I forgot also in the Sekau case. And it's there in paragraph 18, and I just want to highlight it there. They say there, the legal standard for reasonableness is that expected of a person in the circumstances of the individual whose conduct is being judged. The importance to recusal matters of this normative aspect cannot be overemphasized. In South Africa, adjudging the objective legal value to the attached to the litigant's apprehensions about bias involves especially fraught considerations. This is because the administration of justice, emerging as it has from the evils and immorality of the old order, remains vulnerable to attacks on its legitimacy and integrity. Courts then, considering recusal applications, asserting a reasonable apprehension of bias, must accordingly give rise to two contending factors. On the one hand, it is vital to the integrity of our courts and the independence of our judges, our magistrates, that ill-founded, misdirected challenges to composition of the bench be discouraged. On the other, the court's very vulnerability serves to underscore the preeminent value to be placed on public confidence in impartial adjudication. In striking the correct balance, it is as wrong to yield to a tenuous or frivolous objection as it is to ignore an objection of substance. South Africans, let me go there to the last part again, because this, I think, is crucial and goes to the center of what we are dealing with. On the one hand, it is vital to the integrity of our courts and the independence of judges, magistrates, that ill-founded and misdirected challenges to the composition of the bench be discouraged. On the other, the court's very vulnerability serves to underscore the preeminent value to be placed on public confidence in impartial adjudication. Therefore, in striking the correct balance, it is as wrong to yield to tenuous or frivolous objections as it is to ignore an objection of bias. South Africans, what is actually the test? The test, as we've already heard, is a reasonable apprehension of bias on reasonable facts. What are the facts? No, this guy is my friend. What are the facts? No, they handpicked and cherry-picked witnesses to push a particular political project or narrative against me. Basically, my testimony was ignored. It was not considered. And this person cannot be bring an impartial mind to bear. South Africans, it is not enough. It is not enough. It is not supported by objective facts. And in my view, this is not going to work. It's not something that, in my view, is going to work. And one, we have already had Jacob Zuma sit in 7 cases where these objections were not raised. And even then, there were no complaints of this nature raised that there would be a reasonable apprehension. We already had the justice sit in Duduzani's case. These objections were not raised. We already had Mr. Zuma, Duduzane, come to the Commission of Inquiry. These issues were not raised. And even after, he did not complain about the manner in which he was handled. And South Africans, the arguments that Mr. Zuma make relates also to the attack on the legitimacy of the commission on the basis of unsubstantiated claims and reports. Secondly, we know for a fact that the Chief Justice has not pronounced himself or made any findings on any political project, on any intelligence reports, or on anything. And we know that he did not handpick witnesses. There were over 200 and something witnesses that came. And all of these witnesses, over 257 to be exact, that's excluding Jacob Zuma, who came and presented themselves at the Commission of Inquiry. We saw that the chairperson really went out in the public, tried to invite all stakeholders, people that have information, whether they are very top of government or low level, to come and testify. Despite that, if he really had an issue, he would certainly have made a noise and said that Mr. Zuma should not essentially, he would have easily accepted the running around of Mr. Zuma. In other words, to say that if you don't want to testify, it is okay. If you don't want to test the allegations against you, it is okay. I will then make my findings without you. But you can see an insistence on the part of the Chief Justice to get Mr. Zuma to come and tell his side, because he's so crucial to the commission that it cannot really, in my view, meaningfully carry on without his participation. And we really see that the justice has been really courteous and really wanting to hear objectively the other side. And these other people cannot be cherry-picked. For example, the council or the Mr. Zuma cannot pick about 10 witnesses from 257 and say then, objectively speaking, these 10 are pushing a narrative. No, there are 257 witnesses. Besides that, we know South Africa, there are witnesses like Dudu Myeni, Nomvula Mkonyane, Mr. Baloyi, and others that were also pushing the other version that Mr. Zuma is not willing to accept. In other words, there are 2 versions. It's just that the one side is much stronger as far as its articulation, as much as the exhibits that they have, and as a result, he can already see that problems are coming. And that is why it's important that he gets the justice to recuse himself. Lastly, South Africans, we know that when you have a friend and that friend would preside potentially over your case, you will honestly, in all probability, be treated fairly. Is maybe the problem that Mr. Zuma doesn't want an objective, independent, impartial judge, but a judge that will then find in his favor. And that is not the test, that the judge is going to find in my favor, therefore he is not willing to be persuaded by me. So in the absence of the judge already having made up his mind, then it cannot be said really that there is a bias on the part of the justice. Now, the application test, according to authorities, must take place in or account of the specific institutional setting. Remember now, I told you about the adversarial process and inquisitorial process. In an adversarial process, the judge is sitting there, objective, keeping quiet, not saying anything, not asking questions, not doing anything, not putting versions, not making impressions and what, much. But in an inquisitorial process, the judge takes the lead. He comes, he interrogates, he questions, he puts versions, he puts impressions, and those comments can then not be taken to mean that there is a bias. And that is my view, South Africa, the assertion that Mr. Zuma is not going to succeed. And I'm sure you remember when the Chief Justice Mogoeng was being interviewed by the Judicial Commission, and he was asked a question relating to why in one of the cases he said, in a case where his wife was a party, Chief Justice said in a case where his wife was a party, and I remember that interview very well. And so you are worried about a friend. Imagine sitting in a case where your wife is a party. The whole issue relates to the ability to be persuaded by the other party, objectively speaking, on reasonable facts. And if it's your wife, your friend, whoever it is, and you are able to, provided that there's no clear reasonableness of bias, then we won't be able to win. And the context is also important because without that, the context, we cannot meaningfully apply the test in this case. And therefore, South Africans, the other last thing that I want to indicate to you is the implications of this. The implication of a recusal means that we lose almost 1 billion already spent of taxpayers' money. We need to get a new judge. And then the judge will not just recuse himself as it relates to Zuma, but to everything about Zuma, Zuma's family, and that basically is going to lead to the collapse of the commission. So it is, in my view, not in the best interest of justice for the Deputy Chief Justice to recuse himself. And lastly, South Africans, I promise you it is going to be very tough for Chief Justice to Deputy Chief Justice to recuse himself, if not impossible. And the interest of justice do not, in my view, allow. But also lastly, remember, we are not dealing with guilt and innocence here. We are not trying to prove somebody right, somebody wrong. We are just going to, on objective facts, present them to the executive, and those recommendations are also not even binding. So really, to make a hullabaloo at this early stage is quite problematic for me. So having said that, South Africans, thank you very much, and I am looking forward to the final series that looks at what is where my bones lie, basically whether or not I believe that Deputy Chief Justice will then be in a position to recuse himself or not. Having said that, thank you very much. See you in the next series, South Africa.